Ready, start. There was an unwritten law among the Pormandar Maimans living in South Africa that death should be preferred to bankruptcy. It was impossible for Tayyab Seth to pay down the whole sum of about 37,000 and costs. He meant to pay not a pie less than the amount, and he did not want to be declared bankrupt. So there was only one way. Dada Abdullah should allow him to pay in moderate installments. He was equal to the occasion and granted Tayyab Seth installments spread over a very long period. It was more difficult for me to secure the concession of payment by installments than to get the parties to agree to arbitration. But both were happy over the result and both rose in the public estimation. My joy was boundless. I had learned the practice of law. I had learned to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties driven as under. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. In our opinion, the lawyers should advise their clients to try for mediation for resolving the disputes, especially where relationships like family relationships, business relationships are involved. Otherwise, the litigation drags on for years and decades, often ruining both the parties. Hence, the lawyers as well as litigants should follow Mahatma Gandhi's advice in the matter and try for arbitration or mediation. This is also the purpose of Section 89 of the Code of Civil Procedure. Let the matter be referred to the Bangalore Mediation Center. The parties are directed to appear before the Bangalore Mediation Center on 21 February 2014. The next case is of an appellant contractor, a partnership firm engaged in the construction business, who was awarded a contract by the respondent state government for construction of a dam. During the execution of the said work, the executive engineer in charge of the project made a certain additions, alterations, and variations in respect of certain items of work and directed the appellant to carry out the same also. The appellant filed a consolidation statement of claims for the additional works. The trial court decreed the suit for rupees 2 lakhs with proportionate costs and interest at the rate of 6% per annum from the date of the suit till realization. However, the division bench of the High Court allowed the appeal of the employer state government and dismissed the suit mainly on the ground that the plaintiff contractor had accepted the amount as per the final bill under protest without disclosing any real grievance on merits, and it amounted to accepting the final bill without any valid objection and grievance. It further held that the conduct of the contractor in accepting the final bill and thereafter sending statutory notice and filing the suit for recovery of the differential amount was barred by the principle of estoppel. Aggrieved, the plaintiff contractor filed the appeal.